Hey everybody, I'm Brandon Grisco, an attorney with the Northville-based law firm Fossone Bond. I focus my representation here on business owners, human resources professionals, and labor relations professionals as it pertains to HR issues and matters of labor and employment law. And I'm here to talk today about a recent Supreme Court case that came out, a landmark decision really, that provides or extends rather protections in the sex discrimination context to lesbian, gay, transgendered, bisexual, plus, and questioning workers in the workplace. And so this is really a time to evaluate where we've been and where we're going with this. And so the Title VII of the Civil Rights Act of 1964 gave protection to workers based on certain classifications: race, sex, national origin, things of that nature. And up until just within the last couple of weeks, courts were not on the same page with whether or not those protections against sex-based discrimination also applied to sexual orientation, which would be a gay or lesbian worker, or to gender identity, which would be a transgendered worker. And so the court came down and said that yes, indeed, your gender identity and your sexual orientation are sex-based characteristics that are protected under the Civil Rights Act. So as employers going forward, we need to evaluate what this means for us. And some things to think about are that, do your policies and practices cover this type of situation? Do they cover gender identity and sexual orientation? If not, then those need to be updated to make sure that you're protected in the event that some discrimination does occur. As the employer, you can say, well, this was prohibited under our employee handbook or under our policies. Another consideration is, do your current practices handle how you would deal with, say, a customer complaint based on an employee's sexual orientation or gender identity? Do you have something in place that deals with how you would handle an employee who comes in maybe dressed as a different sex one day versus for the last several years that they worked there? These are all things that employers are going to be dealing with in the coming weeks, months, and years since this landmark Supreme Court decision. And so as employers, I think it's really important to marshal your forces, get together with HR, include legal in the discussion, and talk with employee groups and employer groups about how this is going to look going forward and what kinds of changes need to be made in your workplace policies and practices. If you have any questions about how to structure your employee handbooks, policies, practices, or employment contracts, please feel free to reach out to us here at the law firm Fossone Bond, your full-service law firm based right here in Northville, Michigan, and you can reach us at 248-380-0000.